84 ya makwapa pa Likee TV yesese ne da oba channel so obehete adoma na obe subscribe no like no share wona epensem bi etie so ene bi etie na mesese ye bebowura ensem ni mu ntentem ne de ensem etwagu no ye de emo ensem enyina abremo etiefo Bagbin akasa yes na ne nsem ni nyina ochiremu se Supreme Court of a mode manu atu nsem mu. You see, there's a Parliamentary moon seven, is a moon interfere no. See, no, Bagbin or Supreme Court to say, moon step aside or cry. Is a moon step aside. On say, 10 be a bar near Becase. If we were move one, will be moved. Say, by in a Supreme Court, Moonim Rano, Enna, moon chum who free near maybe one. Anka, ubi cry at the moon. And that will be from one more in teacher so. Says no Bagbin, yes, wakasa. Was one step aside the crack, and a bar and nim so papa no or bang a woman nimpa and win him rapa. Na maybe say you boo remana, you could see and some no be about the cahono, ye de Muslim a bebremo.
Leader and MP for the Summit constituency of HMN Sabonso. We're going to hear from him shortly. When my colleague Evelyn Tema spoke to him, is indicated that the speaker was right in adjourning the House a little over almost a week ago. That's last week, Tuesday. But then again, he was expecting something more. Take a look.
The petition that came from Haruna, I understand, was lodged with the speaker. Now, by our standing orders, if a petition is lodged, the member shepherding the petition will be given space to articulate or give vent to the petition. He gives it to the speaker, and the speaker, on account of that, will provide space to that member to articulate the content of the petition. Thereafter, the speaker then refers the petition to the petitions committee to study and report to Parliament. After the report is submitted, then the House could discuss it, interrogate it, or debate it, ensuing from which, if it becomes necessary and the Speaker has to give a ruling, perhaps that could be done, or a directive that could be done. It's not being ventilated on the floor of the House.
He commended the Speaker for adjourning the House on the day.
We saw some pedestrianism creeping into Parliament. And so what he did cured the mischief of the House degenerating into something else. So on that score, and I also looked at his countenance, I agreed with the adjournment. I thought that the adjournment was going to be perhaps for the day, and then maybe invite the leadership to further discuss the way forward.
That's such immense Sabonso there. But there's some latest coming through, a developing story right now, fresh on the plate here on Ghana Tonight. Lawyers of the Speaker of Parliament, Right Honorable Alban for Bagbin, have filed processes at the Supreme Court seeking to set aside the Supreme Court's orders, which suspended the execution of the Speaker's ruling declaring those 4 seats vacant. My colleague Dennis Wadam Esquire has been looking through the documents that we have right now here on Ghana Tonight. Came through not too long ago. What are the Speaker's lawyers saying?
Well, so the Speaker is in court through his lawyers, and he's seeking to, if you like, overturn that particular order from the Supreme Court, which suspended his ruling that vacated those 4 MPs. So the prayer of the Speaker is pretty simple, that he wants that the order of the Supreme Court be set aside, and that the processes and the proceedings in the Supreme Court in this suit be set aside. He also wants that the order be vacated, and this order is in respect of the order that was dated 18th of October 2024. You remember this order that was made by the Supreme Court to the effect that the ruling of the Speaker, which vacated the 4 seats in Parliament, be suspended. The order that the MPs, the said 4 MPs be recognized. So those are the orders that the Speaker is asking the Supreme Court to set aside. Now, what are the grounds? The Speaker is simply saying that that by the rate which the plaintiff had purportedly invoked the court's original jurisdiction as incompetent. He makes the argument that the process or the procedure by which the plaintiff, in this case Afenyo Makin, came to court was not proper and to that extent is incompetent. He also says that the court had no jurisdiction to entertain the matter before it because he argues that this is entirely a question as to the election of an MP or as to whether the seat is vacant or not. He contends that this is for the High Court to do. And that if the High Court, in doing so, comes to a point where they think there's the need for interpretation, at that point they could refer the matter to the Supreme Court. But as it was in the case, he makes the argument that the Supreme Court did not have jurisdiction to even entertain the matter in the first place. He also continues by saying that the court has no jurisdiction to stay execution of a ruling of the Speaker of the Parliament of the Republic of Ghana. On this call, he makes the argument about separation of powers, to say that even though the Supreme Court has the power to stay execution of rulings, that does not extend to such rulings that have been made by a Speaker of Parliament, and that the Constitution clearly defines the kind of orders that the Supreme Court can stay execution on. He makes the case that this is not one of those. For that reason, the Supreme Court does not have the jurisdiction to stay the execution of that. He also makes the case that the processes and proceedings in the suits were filed and prosecuted in breach of the rules of natural justice. We all know that this was an ex parte motion. What it means is that Afenyo Makin went to court without recourse to the Speaker. He was granted that particular relief. The argument made here is that they ought to have been heard. Then there's also the other ground, that the orders of the courts dated 18th October were made in breach of the, we've seen this already, and that the orders dated 18th October were made in breach of the rules of law and procedure, which regulates the court's proceedings and orders. This, when you look at the larger extent of the explanation given here, it makes reference to how even the Speaker ought to have been served. Makes references to the immunity that members of Parliament and the Speaker have in respect of Article 117 and 118, as well as an agreement that had been reached between the Judicial Service,
essentially the Chief Justice,
and then the Speaker of Parliament, where they agreed that members of Parliament should be served only on Mondays. There's a document to that effect that we have seen that, in fact, the Speaker had, as of 18th of October, had written back to the Registrar of the Supreme Court to reject service of the writ that was served on him. So basically, the Speaker is seeking to set aside this particular order, which sought to suspend the ruling that the Speaker made on the matter that relates to the seats of the 4 MPs who are now deemed to have vacated their seats.
So essentially, the Speaker is questioning the jurisdiction of the Supreme Court in entertaining Afenyo Makin's suit.
Yes.
They shouldn't have even paid attention.
They shouldn't have entertained in the first place. It's even questioning the process itself to say that, look, the writ that came before you was incompetent for you to have entertained it because the rules of court have a specific way by which it should come. It makes the argument that this particular writ did not follow that particular procedure. So in the first place, it ought not to have been entertained. And finally, in concluding this, there was something interesting that the lawyers of the Speaker said, that ordinarily with this kind of process, they could have come ex parte. But they think that, no, they don't want to do ex parte. The parties involved should be served. They should be ordered to come to court for the hearing. And he has gone ahead to issue hearing notices. What it means is that come Wednesday, this matter will be heard. You mean the day after tomorrow? The day after tomorrow. This matter is going to be heard. We'll see whether the Supreme Court will set aside the order or to vacate its orders or not. The coming days are going to be interesting. It's very interesting indeed. And as simple as you put it and clear and understanding, Dennis Boberi with them there. We're going to be having some two persons join us for this conversation. But Jose Usu, who is the first Deputy Speaker of Parliament, has also been speaking about this. And let's hear him briefly. I'll be joined by my two guests right now. Take a look.
It's a reflection of the politics of today, of the things that we place emphasis on, of things that, in my view, should be in the background, of things that do not add any value to our work as MPs. I'm disappointed. I think that those are not the things that should take the front stage when we're discussing Parliament.
And you're disappointed, as in it doesn't matter who is on the majority side and who is not?
It does. It does. But while we behaving as we're doing when in the past, in the previous 3 parliaments I've been in, such matters are discussed indoors at the leadership level. How is now playing out in the open? Who is whipping members to be agitated and showing off their machoism? What value does that serve?
What or who could be responsible for that?
I'm not interested in what or who. It is reflecting badly on Parliament. What we should do is, as for having controversy, it has always been with Parliament. The reason Parliament is called Parliament because a reflection of the various shades of ideas in the country. And it is expected, it is natural that members of Parliament will often disagree.
Is what we see today a failure on leadership or of leadership?
Well, I do not intend to make any value judgment on leadership, but for me, we are moving away from the values of Parliament, how Parliament had run over the years. We are demonstrating the worst part of us. Even in the past, there have always been significant differences between the minority and the majority. It is this time that we have almost equal members.
Well, let's bring in 2 people on this. Now, Dr. Rashid Draman, Executive Director of the Africa Center for Parliamentary Affairs. Martin Pebo is private legal practitioner. He's also going to be joining us in a bit. Dr. Rashid Draman, good evening. Thank you very much for joining us here on Ghana tonight.
Good evening.
So that's the latest right now with this standoff we have in Parliament. The Speaker has written back to the Supreme Court questioning essentially its jurisdiction and even entertaining this suit by Afenyo Markin. And in the next 2 days, it's just the next 48 hours to watch. Again, is it not?
Yes, indeed, Alfred. And if care is not taken, this is the running battle that we are going to see between now and the end of the 8th Parliament.
And na for you go so in some way a tremo says 7 December and abattoir ba so let peace prevail no the rubon yenso ya fato ho so a you go so a ye bo eno ne bo monka ye say ye nyina yenke hombo mu ne mu asomdwe ho dawuro enkyere o my Ghana now mine so no emfa ne to mapa infra
where legal issues after legal issues would define the last chapter of this 8th Parliament, which is quite unfortunate. And I just heard the Right Honorable Joe Sewus, the First Deputy Speaker. And I mean, that is a view that I share, and I think that I've said this several times on your network, that this matter it's not a legal matter. That the reason why we have the 275 people representing us is for them to go and sit down and talk. And that, I mean, there will be many times when things are difficult. And when things are difficult, that's when they have to show leadership. But what we see these days is the least kind of difficulty. Then people run to the court for interpretation. And, like I said before, what this does is that it only weakens the hand of Parliament, which is already the weakest link in our democratic arrangement. The executive, as we know, is so powerful. I mean, everybody is calling for a review of the Constitution to reduce the powers of the executive. Now we are seeing a judiciary that is also very powerful. I mean, if what we are hearing from the Right Honorable Speaker right now, all the documents that you read that are before the court, questioning, why the Supreme Court is getting involved in this when it doesn't lie in the bosom of the court. I mean, it's for another level. And so, Alfred, when I sit down and think about all these, apart from, the fact that I repeat what I have said several times, this matter requires a political solution.
A political solution that must be initiated by who? There's been proposals that the president should step into this matter to call both the speaker and the chief justice, or in fact, the MPP and the NDC caucus leadership. What approach, what route should this intervention take? In what form, essentially?
Well, I think, the speaker, the chief justice, the president, I think need to have a conversation, maybe at the first instance, and then eventually involving the leadership of the two parties. We can run away from this for as long as we want. If this political solution is not found, we are going to end up with a situation where no work can be done in Parliament before December 7. And I think I repeat this because
Iramasi Samoje Brewa Daily Update TV.